Yes.
Now, a civilian, whether they have a federal license to carry a firearm or a carry and concealed weapon, that license does not give that individual any power of arrest, does it?
No, sir.
They're not paid to stand in harm's way, are they?
No.
They are not paid, the civilians, even with a carry and concealed weapons permit, are not paid to enforce the laws of the state of Florida.
No, sir.
They're not paid to enforce the county ordinance of a particular locale
No.
or city ordinance.
No, sir.
They're not even paid to enforce whatever local policy a local business might have within the community, are they?
Not necessarily, no, sir.
They have no authority to arrest.
No.
When a civilian asks another civilian to do something and the civilian doesn't respond, there's no consequences, is there?
No, so they have no duty to act generally.
If a civilian doesn't respond to another civilian's request, that other civilian doesn't go to jail, do they?
No, sir.
In fact, the civilian who's receiving the request can say whatever they want to that other civilian with no consequences at all.
Generally speaking, yes, sir.
Mr. Escobar talked a little bit about human factors. I think he gave an example about traffic reconstruction. Remember that?
Yes, sir.
Talked about distractions and focusing and tunnel vision, right?
Yes, sir.
Now, those human factors are in all of us, right?
Yes.
To some degree. Everybody's different.
Yes, sir.
But just because those human factors come in play, that doesn't relieve someone from the responsibility when they commit a crime, right?
Objection, Your Honor, that calls for a legal opinion. Improper predicate for a legal opinion.
He was asked specifically about the traffic accidents, not the traffic, but the reconstruction and the investigation of those types of incidents. And he used those human factors. I have a right to go into those factors and whether or not an officer, knowing those factors, still has the power to make the arrest and that person is still subject to criminal charges. Because all we know, we do have a crime called negligence. Lack of focus, lack of attention. So just because human factors are in play doesn't exculpate an individual. So I have a right to ask him those questions.
Judge, he called for a legal opinion. He can certainly ask him about human factors and how that affects perception, because that's what human factors deal with. But not whether or not those human factors are going to relate at some point in time to someone being charged with a criminal law violation. He is not in a position, he's not a lawyer, he hasn't studied the law to that extent. It's an improper predicate for a legal opinion.
I'll sustain as to the improper predicate and calls for legal speculation. You can otherwise lay a foundation for that or allow it under those circumstances.
Mr. Escobar talked about the interview process, establishing credibility of witnesses. Remember
Yes.
that conversation?
Yes, sir.
And he's asked you numerous questions regarding and touching upon the credibility and bias, if you will, of the police officers at the scene on January 13th. Remember that line of questioning?
Yes, sir.
Now, Mr. Reeves was also at that scene, was he not?
Yes, he was.
Witnesses saw Mr. Reeves shoot Mr. Olson, right?
Yes.
there's no question about who killed Mr. Olson, right?
No, sir.
The only question that day is whether or not Mr. Reeves was going to go home to his family or be handcuffed and taken to jail, correct?
Yes, sir.
Mr. Escobar talked to you about the background of Mr. Reeves, that he's a police officer.
Yes, sir.
He mentioned to you the training that you could have presumed that he had as far as use of force in a given situation. Because you received that information as law enforcement, he presumed Mr. Reeves.
Yes, sir.
That's a logical assumption, right? All right. That Mr. Reeves, over a 27-year period, would have, over those years, numerous opportunities to be schooled and updated in the use of force aspect of law enforcement,
Yes, sir.
both non-lethal and lethal.
Correct.
And you would expect Mr. Reeves, with that type of training, to know exactly what factors are used to determine whether or not deadly force was warranted either under the law or agency policy, right?
Yes, sir.
In all the people that were interviewed on January 13, 2014 at the theater, other than potentially Matt Reeves and Corporal Hamilton, was there anyone else with law enforcement who potentially could have that same knowledge?
Judge, I'm going to make it calls for a hearsay response.
It doesn't call for a hearing response. He asked him over and over, what were you told, what were the witnesses, what facts were given to you by detectives about what witnesses told you so that you can conduct your crime scene investigation. I have a right to go into that.
That's a hearsay, classic hearsay, and he hasn't even laid a predicate for which witnesses he's considering. Even if he related the predicate, it would be hearsay. Bring the witnesses on so we can have a confrontation right against those witnesses.
I'm not offering it for the truth whether or not they had the training, just whether or not he knew it, because what he knew at the time, Mr. Escobar touched upon as far as how he conducted the investigation. And I'm allowed to follow up on that.
Judge, to say with objection, he can't gather from witnesses information that he is gathering for the truth of the matter asserted, and then give an opinion concerning those witnesses' statements. It's
I'm
classic
not,
hearsay.
I'm
That's
not
what- that's
asking
exactly
for an
what it is.
opinion. May I proceed, Your Honor?
Without the exact wording as to what he was told by someone else, that kind of smacks of classic hearsay. So you can ask in general what he was, but,
Did you become aware of any other witnesses on January 13, 2014, other than Corporal Hamilton and Matt Reeves, who had a law enforcement background?
Not that I'm aware of, no.
And of course, it goes without saying that Mr. Matt Reeves, the defendant's son, and Corporal Hamilton were not the subject of the investigation, because on that day, they did not shoot anyone.
Correct.
So of all the people there, it was only Mr. Reeves, with his law enforcement background, knowledge of the factors that can be used to determine whether or not deadly force was in fact justified. He was the only one there on that day.
Yes, sir.
And it was Mr. Reeves who was taken in handcuffs to the back of the theater, sat in a police car, and interviewed by Detective Proctor, was he not?
Yes, he was.
And he gave a statement to Detective Proctor.
Yes, he did.
And that was approximately 1 hour, after the shooting incident.
I believe so, yes, sir.
And during that 1 hour time, Mr. Reeves sat there in that chair until he was arrested, looking down at the evidence down on his feet. Did
Objection,
he not?
improper predicate. He's got to be able to be a witness to that process. He can't speculate as to what was happening anywhere in another room, anywhere in a vehicle, unless he lays that proper predicate, because that's an opinion.
It's not an opinion.
I'm not sure what the question was aimed at.
Let me just rephrase
Rephrase
it.
and make it a little clearer.
Were you aware whether or not Mr. Reeves, before he was interviewed, sat in the theater, in the seat where the shooting took place, with the evidence at his feet?
Yes, I'm aware that he was seated there for some time as the investigation started.
It's an improper predicate, because if he's giving an opinion that he's aware that he was seated there for some time, he had to get it from someone else, because he didn't get in there until an hour plus after the incident. It's classic not laying the proper predicate. If he got that information from someone else, it's being offered today for the truth of the matter asserted. And so we've got to lay a proper predicate if someone's going to be giving an opinion about a happening that they were not in. He was not in that happening because he didn't come into that scene until way, way after.
And Mr. Escobar went over and over about everything that occurred before Mr. Smith got there. He went over and over again about everything that was provided to him so that he can conduct his investigation. I'm following up on what knowledge he had and dealing with as a crime scene detective and why he did the things that he did. I'm just following up on what Mr. Escobar did.
Overruled.
Thank you, Judge. Have you had the life experience of interviewing individuals who have been involved in an event that potentially could lead to criminal charges?
Yes, sir.
Okay. One of the things that a police officer will look at in evaluation of the statement that they obtained from such an individual.
Objection beyond the direct. We haven't talked at all at this point in time about Mr. Proctor's interview of Mr. Reeves, and that's exactly where he's going at right now. It's beyond the scope of direct.
I'm not quite sure what the question was going to be, but clearly there was significant testimony elicited from this witness about the manner in which the whole crime scene investigation was conducted, and to whom he talked to, and what he did, and who said what, and how did he know about this and that. I'm not seeing that, from best I can tell, where the question was going, that's outside of that scope.
Judge,
He asked,
we
just a
never
minute,
spoke
he
about
asked,
the interview of Mr. Reeves. That's the issue. We never spoke about the interview of Mr. Reeves because he wasn't involved in the interview of Mr. Reeves at any point in time. And so he's now trying to elicit testimony that somehow, when you interview someone that's a suspect, like Mr. Reeves, that,
Mr. Escobar doesn't know what's in my head. Now, that's the second time I've made that statement, and I assure you it's just as true today as it was the other
I
day.
think he'd be surprised.
What was the question?
Judge,
I know-
Mr.
I know a lot of
Escobar,
what's in his head.
Let me hear what the question was.
Mr. Escobar asked over and over about the iPhone and the popcorn and whether or not he was told about the interview of Mr. Reeves, whether or not Mr. Reeves said he was hit by an iPhone, whether or not he was hit by any other object. Remember that line of questioning?
Yes.
Well, that's about the interview of Mr. Reeves.
No, that's about a statement that he made to his wife immediately after the incident that he was hit on the face. That's what it's about.
All
And
right.
he can't stretch
What's
it
the
down.
question again, Mr. Martin?
I don't know, I kind of fell in that same situation you were in. I lost track. Guess it happens to the best of us, right?
I'm
All right,
not
let me move
overruled.
on, Judge, and
Let him ask the question, and then we'll go from there.
now, would you not agree that an individual who is facing charges would be highly motivated in order
Objection
to...
calls for speculation. That calls for speculation. There's someone that is charged, just because they're charged, they're now motivated to fabricate. That is the most speculative question I've heard in 34 years of my practice.
Rephrase, please. Rephrase.
An individual who is a potential suspect in a crime has the motive to paint... I felt that presence of someone standing up behind me. It's extremely annoying.
We get to know each other very well during these proceedings, Your Honor.
Judge, let me just I have a right to ask about the evaluation of the information received. Mr. Escobar did not lay the foundation that that information came from his wife. That was not said at all. He kept talking about Proctor and when did they discuss things and whether or not it was used as to hit the phone. Miss Reeves never said that he was hit by the phone. It's Mrs. Reeves. It's Mr. Reeves that said he was hit by the phone. So how can Mr. Escobar say he got that information from Mrs. Reeves because she doesn't know anything about that? So all the question about the DNA and picking it up, and you knew that Mr. Reeves said he was hit by the phone. In fact, I have it written down in a circle. He said he was hit over the head with the phone. That's Mr. Reeves' statement. I have a right to go into it. It's very disingenuous for Mr. Escobar to stand up here and suggest, oh, that just came from Mrs. Reeves, because that's just wrong.
Judge, let's go back to the question, because he's trying to circle around the question. The question was, very simply, someone like Mr. Reeves that's being investigated and charged with a crime, is there some indicia that he has the motive to fabricate? That's what the question was. That is the most speculative type of question that you can have. It has no foundation. There's nothing unique about someone that is accused of a crime. In this country, we are innocent until proven guilty. There is nothing to suggest that someone that's accused of a crime has now the propensity to lie just because they've been accused of a crime. That is outrageous, that's prejudicial, and it has no foundation. It has no foundation whatsoever.
You know,
It just,
it is the most logical thing in the world, and I have a right to ask about whether or not you take that into consideration and evaluating how you do the crime thing. Because I'm going to go, he said he was hitting the phone. Where? I mean, how do you evaluate how you're going to do things without going into the credibility of the witness and so whether or not this man right here has a motive when he's sitting in a cruiser with handcuffs on, knowing that he's going to jail, knowing that only the police officer, he spins the right web, can let him go. That is absolutely relevant to the investigation that they have to do.
all right, Mr. Escobar definitely opened the door to going into the intent and the focus of the investigation. As far as the actual question, Mr. Martin, I agree, though, you do need to lay some foundation as to, that question. So I'll sustain in part and overrule in part.
Mr. Escobar asked you questions about the iPhone. He equated it with a baseball and cue ball. Remember that?
Yes, sir.
Did you see Mr. Reeves at the scene?
No, sir, I didn't.
Mr. Proctor did? Detective Proctor did?
Yes, sir.
In determining whether or not and how the iPhone was to be processed, did you make any inquiry as to any of the injuries about Mr. Reeves that would suggest that he was, as Mr. Escobar lamented, he was hit over the head with a cell phone?
At the time, I don't recall asking any specific injury or information about injuries because I wasn't aware and didn't have information that he had been hit with the phone.
What was that?
If I understand your question correctly, at the time, I didn't have any information when I was processing the scene that Mr. Reeves had been hit by the phone or that I would be looking for any injury.
Judge, Detective Smith will be called in the state's case. I'm going to continue my questioning with Detective Smith at that time, reserving the right to go into the matters Mr. Escobar raised, but I'll do it during my case on direct.
Okay.
Judge, I just have a couple of questions, and I'm going to be, if you want me to recall him, I'll recall him right now, because they're outside the scope of the cross, but it's going to be very, very short.
Any objection?
I'm calling him back, so.
Okay, well, but chances are we'll be allowed to ask those questions if he stays away from the topic. So I apologize. It's going to be very short, promise you.
Sorry.
Short by Escobar standards.
I have no
Okay,
objection.
I'll accept that.
I mean, I'll overrule any objection if there is to recalling him
Okay.
at this point.
Thank you, Your Honor. It's going to be, again, very, very short.
Go ahead.
Detective, I just want to direct your attention to a period of time where you went to Alabama
Yes,
in
sir.
an effort to go pick up some hard drives. Remember that?
Yes, sir.
I mean, who did you go with?
Detective Proctor.
Okay, and why were you going to Alabama to pick up hard drives?
At some point after the initial investigation, we've been made aware by Cobb Theaters that they pulled the hard drives out of the DVRs that were in the theater in Wesley Chapel and transported them to their, I believe it's their headquarters there in Birmingham. Once we were aware of that, we contacted their attorneys and said that we would like to seize those as items of evidence since they were out there and traveled to retrieve those.
Were you familiar at that time as to when they had gone to retrieve those hard drives?
No, not as far as what date they had taken them out, no, sir.
Did you know how many hard drives were in the system? Did you actually look at the DVRs the day of January the 13th of 2014 to determine how many DVRs were in the system?
I did not look at them. I think I was aware that there were 4, I believe, in total, but I honestly can't say where.
4 hard drives?
No, 4 DVRs.
Okay, well, that's my question. Did you look at the DVRs to see how many hard drives were in the DVRs on January the 13th of 2014?
I didn't look at the DVRs themselves at all that day.
And in fact, when you went to Alabama to go retrieve the DVRs, you went to an attorney's office, right?
Yes, sir.
You didn't go to this IT person that you believed was competent for Cobb Theater.
No, sir, he was not in possession of the drives.
You went to an attorney's office. And there at the attorney's office, did you get a suitcase of some sort?
Yes, sir. It
What do
was
they call it, a packing case or something like that?
this one called the Husky case is just a protective black plastic case.
Okay, and what was the condition of that Husky case when you first got it?
It had been locked with a padlock and had a numbered seal on it to prevent it from opening.
Okay, and were you given the key?
Yes, sir.
And did you open it?
No, sir.
Why not?
The items we were given, a inventory sheet, that Cobb Theater, where they laid out for us what was in the box. At that point in time, we were not looking to analyze the drives for anything. We were picking them up as physical evidence to retain, and I could not have told you at that point. He could have bought a hard drive at Best Buy that afternoon and put it in, and I wouldn't have known the difference or had
Well, but
any way.
I would imagine you want to open the box and at least count them, right? Because you got a sheet. Let's see, 1, 2, 3, 4, 5, 6, 7. You want to count them, right?
Not at that point, sir. We wanted to leave the box locked and sealed because it would be eventually on the testimony of the IT professionals that put them in there because they'd never been in a law enforcement chain of custody of any kind.
Well, maybe not the IT professionals because it's gone through somebody else's hands, right? An attorney?
Yes, sir, at some point. Excuse me. Who locked the case, I'm not sure of.
Well, why didn't you ask? Since you were there at the attorney's office, why didn't you ask?
Honestly, I may have, but I don't recall what the answer is or for sure if I did.
Or did you memorialize that maybe in your police report?
I can double check,
Anytime
but
you-
I don't think so. No, sir, I did not note who had actually sealed the box. I know the inventory, I believe, was signed by Mr. Andrews, their IT professional, but.
Okay, so you get a sheet of
sealing-
paper that's signed. You don't look in the box. You take the box, you get the key for the box, but you don't open the box.
Eventually we did, but not while we were up there, no, sir.
Okay. And so now you leave Alabama,
Yes, sir.
and on the trip to Tampa, do you open the box?
No, sir.
And so now you get to the property room.
Yes, sir.
So what do?
It's secured as it was.
You open the box before you gave it to property?
No, so the seal was left intact on the box when we put it in the property.
No further questions.
Any cross as to that?
Judge, I'll handle that during my case.
All right. May this witness, well, it can be released for now,
For now.
and you'll remain under subpoena, either by the defense or the state, and subject to recall at another day, right? Not today. All right, then you're free to go for today.
Thank you, Your Honor.
Thank you. Who's gonna, I know we're at the lunch hour and we're gonna break. Who's our next witness anticipated?
Mr. Knox.
Oh.
He's my homicide reconstruction
Mhm.
expert.
All right, and I would anticipate that taking a bit of time. And then you anticipate one other witness after
My
that?
use of force expert.
Okay,
And Judge, I think we're doing what I think time-wise, and so I'm hoping,
how about if we come back at 1 o'clock?
perfect.
All right, then we'll be in recess for lunch till 1 o'clock.
All right.